Good evening to the participants of the Law and Economics, that is SLW616, if I not be mistaken, the code. Yes, can anyone can unmute, read what I posted on the screen? Could you see this one? Anyone? Anyone can unmute and read what I posted on the screen? I think there is a problem of internet. Anyway, welcome to the students of the SLW616 of the South for the blended mode class on the 3rd December 2022. And here I have shown the equality, equity, and reality. So, which one you prefer, the equality or equity? Which one is the good one? In the law, we can say equality before the law and the equal production of the law. But when you practice, it is the equity will be the quite good. And the reality is different. Equality, here you can see the pawn in the chess, PAWN pawn. Later on that you could see either the camel or the queen or later the king. These are the things. In the equity, there is rise the bottom of the pawn and they made the equal. Yes, Fidelis Kitange, Karibusana to the class. Late is better than never. Could you see what is posted on the screen, Kitange?
Yes, Prof, I can see it.
Read.
Welcome to the students of SLW616 of Saudi for the blended more classes on 3rd December 2022. Equality, equity, and reality.
Keep your gadget near to your mouth and you have to read with the sound so that the sound would be like a sonorous voice. Sonorous, sonorous. Yeah, what are these things here? Could you tell me? This I know it is a chess. What is this coin? Do you know what is chess?
Also, no, Prof, I don't know.
This is pawn, PAWN pawn means soldiers. To my knowledge, it's either camel or a queen, and this is the king. So if you want to make the equality, here a little with the same amount will be given over there. For the pawn also same amount, for the queen or the camel, whatever it may be there, the same amount, and the another pawn also same amount. In the equity, here the bottom line is not the same, the upper line is same. And in the reality, neither the bottom is the same nor the upper is the same. That is the reality. Are you following me?
Yes, Prof.
In sometimes you can see, as I gave that example, in the theory, a Muslim can marry four wives. It is a theory. But in practicality, in the reality, it will not happen. So here, law seems to be done, means justice to be done, and it seems to be done. So the equity should prevail over there rather than the equality. But the reality is entirely different. In economic theory, we see in terms of the money. And this is also economic way. Say rise by keeping the money means the person who is a big what I say rich man, he become more rich, and a middle rich man become middle rich, and the no money man will be remain as a no money. Is it clear? Kitange.
Clear, Prof, it's clear.
Okay. Now let us go to our last class, economic theory is concerned, and not for the debate and for the thing that we discussed more. Now let us see the law and economics offers a framework with which to model legal outcomes. And a common objective with which to unify the disparate areas of the legal activity. The law should be applicable to even a poor as well as the rich as well as the middle. So there would not be any distinction. There should be a reality also, it will be like that, equality also is like that, and equity. Perhaps the equity principle will be used over there, that is the ethical principles. The bringing together of the legal theory and the economic reasoning has also created a new research agenda in the field of the behavioral economics. When you want to make it of the behavioral economics, they will see in terms of the finance. And if you spend at least, say, about the 20 lakhs Tanzania shillings for getting the 10 lakhs Tanzanian shillings, is it a wise idea? Spending the 20 lakhs Tanzanian shillings for getting the money damages in the form of the damages through the court or from the court by the award 10 lakhs Tanzania shillings. There is the economic viability is there. Please speak. If you did not understand the
Sorry,
question,
Prof.
say, sir, I did not understand the question.
I didn't understand the question, Prof. I was trying to connect it, but I failed this. So can you repeat, please?
Why you are not saying? I repeat, spending the 20 lakhs Tanzania shilling for the sake of 10 lakhs Tanzania shilling as a damages. Is it a viability? Did you
That's
understand
not
the
right,
question?
Prof. Yes, to some extent. I didn't hear the last few words you said. That's why I
Why
failed.
you could
But I
not hear
think
the last few words? I am having the same tone and the same way of the speech. I repeat,
as a,
spending 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 20 lakhs Tanzania shilling for the sake of getting the damages from the court 10 lakhs shillings. Is it viable?
no, Prof.
Did you understand the question?
Yes, I can explain it in different ways. It's like someone is trying to spend maybe 10, 10 million so as to get it maybe 5 million from the court award. That means it's not proper.
There is no viability. That means
Sure.
it is useless to spend 20 lakhs Tanzania shillings to getting the 10 lakhs Tanzania shillings. I said in the lakhs, you said in the millions. Doesn't matter. It is no. So, economic viability also taken into consideration. And moreover, waiting for the 30 years, getting the justice, and that to be the spend of a lot of money, even justice also be given, it is a useless. And hence, nature, depending upon the nature of the case, there would be a fixed time limit. For the civil cases, not more than 3 months or 4 months. For criminal cases, not more than 15 days and 1 month. Immediately, the disposal of the cases should be there. It is not taking years together. For the murder case, it will take 7 to 10 years if that fellow is hanged to death or convicted. It should be expeditious manner it will be done. Then only people will have a trust in the court and people will tap the door of the court. Otherwise, like the example which I have given, spending the 10 millions for getting the 5 millions, as the form of damages. So that would be the idea. So here, the bringing together legal theory and economic reasoning has also created a new research agendas in the field of legal scenario, in the field of behavioral economics. How rationality affect the people's behavior within legal scenario, public choice theory, and how collective behavior should have an effect on legislation, and game theory, understanding the strategic action in the legal context. A different theories should be evolved over there, and whatever the theory could make it out, there should be a benefit to the party, and the time consuming should be less. And these are the factors you have to adapt it before any theory would be adapted in the decision making. Of course, here the table of contents are there. Let us see law as an autonomous practice. Most traditional theories of the jurisprudence look to uncover the essential or definitive aspects of the institution of law. Two of the most influential are legal positivism and Dawkins' law as integrity. So these are the two approaches, while those two differ as to their definition of law and legal reasoning. They agree upon some basic central assumptions determining the conclusions. The two philosophical investigations with largely the same aim can reach. Because of this, it is important to acknowledge some of the assumptions that are held in common by the jurisprudential stances. Each, like Thomas Hart, Dicey, Salmon, Austin, they have a different school of thought, and they define the law in a different fashion. But here, only two people ideas will taken into consideration in the jurisprudence of the law. That is the influential that are a legal positivism, one thing, and Dworkin's law as an integrity. These are the two, and they are two differ as to their definition of law. Legal positivism will give the different light on the law, and the Dworkin's law will give the definition of law in a different manner, and the reasoning they have shown in a differently. But they are agree upon some central assumptions are there. That is determining the conclusions. The two philosophical investigations with largely the same aim can reach. Because of this, it is important to acknowledge some of the assumptions that are held in a common by these jurisprudential stances. So let us see what are the other two common factors. First, both the theories agree upon the conceptual nature of jurisprudence. So they agree for the conceptual nature of jurisprudence. Number one, legal positivism. Number two, Dworkin's theory. Both agree. Here both means, who are the both here? Give me the answer. Kitange and Professor Hussain.
Repeat the question, Prof. I'm following, but I didn't get the question. I'm in touch. Repeat the question, Prof.
I read there are two school of thought, or there are two persons theory would be taken into consideration in the jurisprudence regarding the definition of law. And that I read also the first theory is the legal positivism. The second is Dworkin's theory. And both the theories are agree for the conceptual nature of the law. So here both means
Both means the positive legal theory and Dawkins theory, they agree on the same nature of philosophical nature of law.
both theory means
They
both means here legal positivism And the
Only
second one
the
is
other one.
Dawkins theory.
Yes, Prof.
They both agree that it is important for a philosophical theory of law to define the core aspect of proper legal practice in order to fulfill the function of the philosophical jurisprudence. They thought in the philosophical jurisprudence how the law would be defined. In fact, much philosophical discussion of law assumes that such a characterization is the essential aim of jurisprudence. Why law would be needed? A simple answer is you take any theory. Law is a bundle of rules and regulations binding in the society for the smooth running of the society. Now you can give the color to any way. Law is nothing but a state, and state will regulate it. But state will make the enactments. Through the enactments, it will regulate it. If anybody violates it, there is another enforcing body is there, and the enforcing body will take the action. So it has intertwined for each one with the each one. And here essential aim of jurisprudence. Second, in order to arrive at a properly analyzed concept of law, both legal positivism and the Dawkins, and the law as the integrity are the best constructed from a specific technique of analytic and linguistic philosophy. They say analytic philosophy, linguistic philosophy, philosophical thought. You make anything, but the ultimate aim is to smooth running of the society. These techniques include the investigation and clarification of the way people commonly speak about law and careful parsing of the social practice that separate the legal from the non-legal. So the day by day, when the law is improved over there, whether the criminal rate is increased or decreased, I repeat the question. Day by day, law is increasing in the form of enactments. Then the society criminality is increasing or decreasing.
Decreasing.
Increasing, Prof.
Decreasing because the aim of the law in the society, among of the aim of the law, I mean the purpose of the law in the society to protect the criminals, to protect the crimes in the society. So because there is a law, it means that it's there in order to protect, in order to prohibit people to commit a crime, crime in the society.
So criminals are increasing or decreasing?
Criminal, it means it decrease. It must decrease.
So in your view, it is decreased.
Oh. Yes, Prof.
If it is decreased over there, how Mrs. Hamida was murdered by her own house girl in the house? And hence, a law should be deterrent, and the perpetrator should have the fear that if he could does a particular thing and he will be punished, at that instance, the criminality will be decreased. But not merely the criminality will be decreased by the enactment of laws, but the people should have the fear of God also. And they should not think that no one is looking at me, can steal, can do whatever they like it. If the fear of the God would be there from the childhood, which is taught in the schools as well as the parents, at that instance, it is a sin to do a particular thing which is illegal, and the people get the fear of it and lead their life in a peaceful manner. A charity should not be only from one person. A charity begins from the home. If such a thing is there, and naturally, even a enforcing body also, they will work hard, and punishment also made a rigorous, and that to be within no time. At that instance, the criminality and the criminal behavior of the persons will be reduced. So all the society people, including the court, including the police, they should have to work together to see and bring the peace in the society. If not, it is a barbaric way. The people will kill one another, and who is strong will kill the weak. So that is the right is becoming a might. Our might is becoming a right. That is the appropriate word. A mighty man, he will get the right. Means strong man only the wins in the race. And now the law also should be made in such a way it will be come to the rescue of the not only the rich, even middle class, or the marginalized people also. That is the reason if you don't have the money for engaging the legal counsel, the court, the government will give the legal aid to you to protect you. Am I right? Speak.
Yes, Prof. Yes, yes.
I appreciate. So here, social practice and separate the legal from the non-legal. A legal and non-legal, the difference could be known if the society would be learned. So hence, the government should not give the money. The government should not give any other allowances, but the government should have to give the free education. If the free education is given to the people, people know how to get the money, how to earn the money. So the third common assumption is that the best way to understand the legal practice is to understand the necessary and sufficient qualities that make some rule or statement into a law. So a practices or assumptions, a good outcomes should have to come through the law. Once such a set of necessary and sufficient conditions is identified, and it is thought that the essential aspect of particularly legal practice have been understood. So if you want to get 1,000 Tanzania shillings from the court, at that instance you have to spare only little money, not equivalent to that money, not more than that money. See, the people will tap the door of the court. Why? A justice should be done to them. When they want to get the justice, and for the council he will spend the equivalent amount of the amount which is going to get as a compensation, then what is the benefit to a person who tapped the door of a court? So my point is, even avoiding the damages, they will see the economic analysis also. And they will also give till the amount will be paid. Up to that extent, the interest also to be paid. So instead of the following this path, theorists within the law and economics movement have attacked the study of law from another angle. Let me see what the angle they have made it. Rather than trying to identify the unique conceptual aspect of law that is advocated, is an investigation of legal practices through the means of the economic analysis. So investigation, it is also time-consuming one. If it is investigation should be made within a stipulated time. Otherwise, there is no economic benefit to either to the state or to the party. The conclusion offered here that a legal practice is the best understood through its function as a social tool promoting the economic efficiency in common with the other social practices. Even not only the social justice should be given, even economic viability also or economic efficiency also will be measured whenever the decisions are given. And the court fee also, it depends upon the nature of the case. The court fee should be paid. Now let us come to the matter of the counsel fee. Of course, some people will be happy with a little amount and some people want the more money to argue the case. It depends upon the supply. If the cases are more, naturally demand is more. If the cases are less, the demand is less. Am I right? Participants, don't be silent.
Yes, Professor. We are together.
I don't hear you well because of the network.
I told you, if the necessity comes, sit on the Kilimanjaro for getting the strong signals. Or Mount Meru. Or Pembeni to the tower. So now let us come to
Maybe
let us come to the efficiencies
maybe
are
she has to
concerned.
sit to the strong the rock there. She has to stay in the rock.
Instead of going to Mount Meru, you throw the Kimeo phone and get the nice phone.
The Kimura one.
So, economic efficiency will be counted. You cannot go to the Mount Meru to climb and sit for the class and come back to the home. So, economic viability also will be taken into consideration. So, that is a very important factor in any aspect is concerned. Sir, your classes are very ghumu, sir, because there is no economic efficiency. That's a lot of no. Don't show your poorness. Don't show your maskini in the learning institutions. Are you following me?
Yes, Professor.
So,
Yes, Prof.
law as a tool of to encourage the economic efficiency. So now I told you nobody would spend 20 millions for getting the 10 millions compensation. I don't know whether you saw in the newspaper or not. You know Reginald Mengi, the business tycoon.
Yes, the red one.
Of course, I believe that he is no more
Yes,
now.
we know.
Yeah, he is the late now.
Yes, yes. Say there is and he is running the newspaper. What is the newspaper? What is the Reginald Mengi's newspaper? Hingreza.
If I'm not mistaken, it is the Guardian.
The Guardian. So in that Guardian, there is one article was published which is said to be the different defamation regarding the, is it Banji or Manji?
Manji.
Full name?
Yusufu Manji.
There is an article published in the newspaper regarding the Yusuf Manji, and he filed a case against the defamation against the Reginald Mengi, who is the publisher. And do you know how much the compensation is given by the court? 1 Tanzania shilling.
Yes, 1 cent.
The question is here, they don't see the economic efficiency there. They see the reputation. Are you following me?
Yeah, yes, Professor.
People will not spend. See, for getting the one Tanzania shilling, how many either lakhs or millions he spent it? Can you imagine? But there, it is a question of not the money, it is a question of reputation. So people will die for the reputation. It's not the money. Are you following me?
Yes, Professor. But
Now the
it
question
depends
comes
on
over
the...
here.
Okay.
A man with a low income group, can he do so?
No. He can't.
He cannot.
Yeah.
Because it is difficult for him hand to mouth life. It is the life of him hand to mouth. You know what is meant by hand to mouth? If he works with the hand, then only he can take the morsel of the morsel, morsel, morsel of food into his mouth. That is called hand to mouth life. So one cannot expect it, and he cannot have the money to file. But really, somebody's human rights or the rights are violated, and some NGOs will file on behalf of them as a class representative suit or PIL, public interest litigation. Because they don't have the money to file a case against the state or against the body who violated the rights. Then they can come forward and do the things. And some places, a legal aid committee also will give the counsel for the poor who could not defend his case. So my point of view is there. Law is a tool to encourage the economic efficiency. So they want to see that in a nutshell manner, the case would be decided without spending more money or more time. So the law practitioner of law and economics looks at law as a social tool and tries to evaluate its functionality. So law should be measured in the terms of the functionality, and they evaluate the cases depending upon the nature of the cases. And what is emphasized is not its uniqueness as an institution, but it is a place within the general and common economic structure of the society. In the structure of the society, there is a rich man, there is a middleman or middle income group, and the low income group. So naturally, there would be a much pressure on the downtrodden people by the rich people. And that is another reason the people, those who are marginalized, the people, those who are poor, or the people who are below the poverty, just they will make the patience and listen to the boss. If you don't listen to the boss and you don't have the food to eat, and there is no other thing that you have. Suppose if you have the good education and you can make your own living, at that instance, knowledge makes the man to lead a life in a perfect way, number one, and the people will not beg. People will try to find the earnings by taking the loans from the bank to start their own small scale industries. So the descriptive claim most of this associated with the law and economics is that legal practices are best characterized as the tools for encouraging the economically efficient social relations. So the law of economics plays a role that it maintains the social relations, and to understand the claims, it is important to examine some of the basic concepts used in the model of economic reasoning. What are the models? What are the theories? We can use it for getting the economic reasoning. Let us see. The one is here, which is given here is, why it is coming? I don't know. Okay, that doesn't matter. Basic concept of economic reasoning. Anyone can unmute and read this paragraph up to this extent? Participants,
Essential to an understanding of the law and the economics movement is a set of fundamental concepts. Concept, the most central assumption in economics is that human beings are rational maximizers of their individual satisfaction and in turn respond to incentives.
Yes. So when you analyze this point, essential to an understanding of a law essential, one should have to understand it. And economics movement is a set of fundamental concepts. So there should be economic movement, and that is a fundamental concept. When you want to implement the law or to understand the essential of the law, the most central assumption in economics is that human beings are rational maximizers of their individual satisfaction. If you see it, a man wants to have individual satisfaction. Like Yusuf Banji wants the individual satisfaction that he won the case. Even though he got only 1 tangier shilling as a nominal damages. It is the satisfaction of a person because he could have a good amount of the money and he could do so. And in turn, response to incentives. What is the incentive he got it by winning the case? The incentive is his reputation is not lowered, number one. And whatever it is published in the newspaper is a false one. That means there is no stigma on him. So that is an incentive. And a rational maximizer of a personal satisfaction adjusts means to end in the most efficient way possible. A rational maximizer of a personal satisfaction adjusts means to ends. The justice should be made to the maximum satisfaction of the injured person in the most efficient way or possible way. It is important to realize that economics, as understood here, is not restricted to analyze the monetary issues. It's not only to analyze the monetary issues, there are non-monetary as well as the monetary satisfaction also. So now can you tell me what is the non-monetary injury? What is the monetary injury to the victim? If you know it, you tell me. If you don't know it, you say pass on.
Prof, let me try.
Yes.
For the sake of non-monetary injuries, maybe we can say loss of reputation, maybe if it was the matter of
You are
defamation.
right.
Then in case of monetary satisfaction, maybe the person has lost his property.
No, the person who suffered the loss because he lost his leg in the accident. At the time, the bills which is produced, it is countable in the form of money. But the stress and strain is there non-monetary. And where the bills are produced over there, that is their monetary. The monetary losses occurred over there.